This is fun. Kind of nerve-wracking, you know.
You'll be fine, don't worry.
For those coming in, we'll just take a moment to let everybody load into the event.
Is that you, Tiara, who is doing all of this directing?
That is Monica.
No, it is Monica. It's Monica.
Oh, you came back.
Okay. We are probably ready to go. I'm going to go ahead and stop sharing the slide and let you take it from here.
Thank you very much. Good morning, good afternoon, and good evening. My name is Chiara Giorgetti, and I'm a professor of law at Richmond University Law School and the chair of the Academic Council of the Institute for Transnational Arbitration, the ITA. It is my distinct honor and pleasure to welcome you for today's Preserving Perspective session. It's the oral history interview honoring Judge Gabrielle Kirk McDonald. These interviews are part of the ITA Academic Council's Oral History Project to recall the evolution of modern international arbitration in the world of those who lead it. The interview today will be conducted by Professor Victoria Shannon Sahani, and before I will pass, and I will introduce her briefly before she will introduce Judge McDonald. Victoria Shannon Sahani is the Associate Dean of Faculty Development and Professor of Law at Arizona State University Sandra Day O'Connor College of Law. She's also the Director of the Faculty Inclusion Research for System Transformation Initiative, or FIRST initiative, university-wide initiative commissioned by the ASIU President's Office examining the history of race and inclusion among faculty of the university. Professor Sahani holds several leadership positions, and she's also the Vice Chair of the ITA Academic Council. And I am so glad that she is the chair. She's the Vice Chair. Professor Sahani is the author of many books, including one on third-party funding in international arbitration, a pioneer book, as well as numerous book chapters, articles, essays, and blog posts. She has earned her undergrad degree from Harvard University and her law degree from Harvard Law School. Thank you very much, Victoria, and over to you to introduce this wonderful interview today of Judge Gabrielle Kirk McDonald. Thank you.
Thank you so much, Chiara, for your very kind introduction. And I've greatly enjoyed serving with you on the leadership of the ITA Academic Council. I am delighted to welcome you all here today virtually, and thank you so much for being here. As Chiara mentioned, I'm Associate Dean Victoria Sahani of the Arizona State University Sandra Day O'Connor College of Law, and I'm pleased to also chair the Preserving Perspectives project that is run by the ITA's Academic Council. So as Chiara mentioned, today's interview is part of the Institute for Transnational Arbitration's Preserving Perspectives project, also known as our Oral History Project, in which the leadership of the Academic Council seeks to capture the stories and histories of the most eminent arbitrators and jurists in the world. We are also grateful to the Women in International Law Interest Group of ASIL for their support of this event as well. And we encourage you to attend their presentation of the 2021 Prominent Woman in International Law Award to Judge McDonald on Thursday, March 25th. I'm especially grateful to Judge Gabrielle Kirk McDonald for having agreed to be part of the project and for inviting me to serve as her interviewer. So thank you so much, Judge McDonald. And I very much look forward to our conversation. To encapsulate Judge McDonald's life and legacy in the few minutes we have today is a tremendous challenge, but we will do our best to explore some of the highlights of her career and the extent of her impact and legacy. She herself encapsulates her long and storied career by saying that she is a civil rights lawyer who became an international judge. Rather than reciting Judge McDonald's distinguished biographical volume, including her multitude of awards, honors, leadership positions, and board memberships, which you can find detailed in various locations on the internet. I would like to intersperse key facts about her life into our conversation at the appropriate moment. So we will be moving through her life chronologically, and we will intersperse those tidbits at the appropriate moments. For now, I'd like to set the stage for what is to come. And I will begin with 3 poignant quotations about Judge McDonald. First, journalist Kitty Feld published a profile of Judge McDonald in both the Los Angeles Times in 1999 and the Human Rights Brief in 2000, in which she called Judge McDonald the most powerful African-American woman in the world. The late Kofi Annan, Secretary General of the United Nations, in his foreword to the book Essays on ICTY Procedure and Evidence in honor of Gabrielle Kirk McDonald, which was commissioned to honor Judge McDonald's groundbreaking presidency of the International Criminal Tribunal for the former Yugoslavia. He said this about Judge McDonald, quote, "She used her position to bring international humanitarian law and its enforcement to the attention of the peoples of the world. If the public has come to demand respect for the basic values of humanity and the rule of law in the resolution of armed conflicts and the restoration of peace, that is due in no small part to Judge McDonald's efforts. Indeed, perhaps more than any other single person, Judge McDonald helped bring us closer to a world which once seemed beyond attainment, a world in which those whose deeds offend the conscience of humankind will no longer go unpunished, in which human rights will truly be universal, and in which the rule of law will finally prevail." Finally, Secretary of State Madeleine K. Albright gave remarks in 1999 at a dinner hosted by the American Bar Association's Central and Eastern European Law Initiative. That dinner was in honor of Judge McDonald, and it was held at the United States Supreme Court in the Great Hall with several Supreme Court justices in attendance, including Justice Ginsburg and Justice O'Connor. Secretary Albright said, and I quote, "Her example reminds us that we can understand that there will be limits on what we can accomplish without ourselves limiting unduly what we attempt. And that in doing so, we may achieve more than was ever believed possible. We may seek justice, we may serve the cause of peace, and we may do our part in creating a future that is better than the past." And with that, let us begin. Judge McDonald, as a child, you experienced your family being turned away from apartments located on Netherlands Avenue in Riverdale, New York, because you were African American. And then decades later, you became the president of the International Criminal Tribunal for the former Yugoslavia at The Hague in the Netherlands, resolving charges of violations of international humanitarian law. So let's begin at the beginning. Why did you want to become a lawyer? And what was it like to attend Howard Law School in Washington, D.C. in the early 1960s?
Well, thank you, Victoria. You know, I know Kitty Felve, who mentioned that I was the most powerful African American in the world. And I remember telling her, "Have you not heard of Oprah?" Obviously she hadn't, but that's nice to hear. I haven't heard that in a while. Well, yes, I have said that I did not want to be a lawyer. I wanted to be a civil rights lawyer. It was primarily because of the times and my experiences. It was during the turbulent 1960s. The Reverend Dr. Martin Luther King had given his "I Have a Dream" speech. Medgar Evers, who was president of the NAACP in Mississippi, had been shot down in his driveway. These were difficult times. And Howard was really the center for the development of the civil rights campaign to end segregation in the public schools. Thurgood Marshall, who also attended Howard, he graduated a few years before me, but he was one of the leaders, but also Charles Hamilton Houston, who was the dean of Howard Law School, perhaps not officially, because in those days, his race would not permit it, so there was a white dean, but he was the scholastic or the scholarly influence. He had said that he told really his students that if you are not any lawyer who is not a social engineer is a parasite on society. So that tells you what we were trained to do at Howard. And it turned out to be the case.
Well, that's wonderful. So while you were at Howard, you served as notes editor on the Howard Law Journal, and you graduated as valedictorian, first in your class, from Howard in 1966. At that time, there were only 142 African-American women lawyers in the entire United States. Must have been very lonely for you.
Well, that's a good way to look at it. Actually, I was thinking that I'm really old.
You're just become a vintage. We'll put it that way.
Yeah.
How about that?
That's good.
So your first job after graduating from Howard was at the NAACP Legal Defense Fund, working under the luminaries of civil rights litigation. So in 1966, you were interviewed and hired by the great Jack Greenberg, who was director counsel of the NAACP, and he was one of the lawyers involved in the landmark case, Brown versus Board of Education, that ended segregation in public schools in the United States Supreme Court. In 1967, you personally led the NAACP LDF case that was the first significant victory for plaintiffs in an employment discrimination lawsuit under the newly enacted Title VII of the Civil Rights Act of 1964, which was enacted while you were a student. And that case was against Philip Morris, a company that is today heavily involved in international arbitration. After you left the NAACP Legal Defense Fund, you continued representing civil rights plaintiffs in private practice at McDonald and McDonald in Texas. You practiced as a successful employment discrimination attorney during the 1970s, winning large judgments for your clients, including the 1976 case, Bush versus Lone Star Steel, in which you won a $1.2 million settlement, about $6 million in today's dollars, for front pay for African-American workers that were denied seniority. Then in 1979, President Carter nominated you to the United States District Court for the Southern District of Texas in Houston as the first African-American female federal judge in Texas, and only the third African-American female federal judge in the United States as a whole at that time. You were only 37 years old. As a federal judge, you presided over many high-profile cases that involved a variety of different industries and litigants. And I urge our participants to look up some of the colorful cases that Judge McDonald presided over. We unfortunately do not have time to address all of these fascinating and impactful cases. So let's just focus on one. That is the extremely high-profile Vietnamese fisherman case in which the Ku Klux Klan became involved. So in international arbitration, we talk a lot about conflicts of interest and disclosure for the purpose of ensuring integrity of the system. In this particular case, Louis Beam, who was a top leader in the Ku Klux Klan, he had the title of Grand Dragon, was a party in the case. And he called on you to recuse yourself due to your African-American race, which was clearly a bogus argument. You famously said to the defendant during the highly publicized hearing in a courtroom that included robed Klansmen, you said, "You are not entitled to a judge of your choosing, but one who will be fair, and I will do that." So tell us about the impact of your remaining in this case and presiding over it.
Well, first, let me take you back a little bit because you fast forward through many, many years. And thank you for doing that. At Howard, when I got to Howard, it was transformative. it was liberating for me because I had spent my entire life, really, school life, going to schools where I was most often the only Black in my classes, sometimes in the school. So it really was at Howard that I was trained by the former architect of the campaign to end segregation in the public schools. It was at Howard that I learned the law, but I learned that the law was not an end unto itself. When I got to the Legal Defense Fund, I learned how to apply the law. The Legal Defense Fund is the premier civil rights organization. It was then, it is now. It's argued more cases in the Supreme Court than any other organization. So by the time that I became a federal judge, I had, I guess, been around, so to speak. I had argued many cases in the South before district court judges. And we from the Legal Defense Fund, or at least I can speak for myself, were not well received. I mean, you could look at the judge and tell that he would rather that you not be there. I was determined that once I became a federal judge, I would be different. I looked upon the district court as the people's court and said that when we were sworn in. So when the case fell into my court, and there were 8 judges in the district, we had what, theoretically, we had random selection, which meant that when someone filed a case in the clerk's office, there was, it was not computerized, but there was a stack of index cards, and they would take the top card, take off the tape, and attach that card to the file. How did I get the case? I don't know. The chief judge told me eventually, oh, well, you were the one who needed to have it. I don't know what that meant. So I was determined, based on my past experience, to give a fair trial. The Grand Dragon, however, thought otherwise, and he filed a motion to recuse, asking that I recuse myself. And he testified in court, in open court. Actually, the participants, the observers, were not in their robes. That was one of the issues that arose pre-trial, and I suggested that they not appear in their robes. But in any case, he testified, and he testified that I was prejudiced against the Klan, that all Negroes are prejudiced against the Klan, that I had worked at the Equal Employment Opportunity Commission representing Negroes, as he put it. But the statute, the recusal statute, requires that the judge you must demonstrate, at least, that the judge showed extrajudicial bias. And so I questioned him. And I asked him, you know, had he ever heard me make negative remarks about the Klan? And he said no. In any case, it became clear that my race was the reason. And I denied the request that I recuse myself. I firmly believe that I gave him a fair trial. Most of the incidents that were the subject of the lawsuit, which was brought by Vietnamese fishermen against American fishermen, because they were denying them their fair right to fish. Basically, it was an economic case, but underneath it, they had racial overtones. I denied the motion to recuse, and they did not appeal. I mean, as I look back upon it, I think that the Klan welcomed the publicity of having a Black judge preside over the case, and the Klan and the American fishermen could have filed a motion to have the matter transferred to the Galveston division, which was closer to where the events occurred. So the impact, though, was major. The Attorney General had intervened in the case, asking that the paramilitary camp that the Klan maintained be closed as a violation of state statutes that prohibited private militias. I sat actually in chambers and reviewed hours of video, watching the Klan, run through the woods, playing war, but it wasn't a game. So I also shut down the paramilitary camp. The impact was great because there was a rise, as there is a rise again, of basically terrorist organizations, and that prevented them at least from training in the state of Texas. They could move elsewhere. Actually, I have found out in the last couple of years that contrary and in violation of the injunction that I entered, the Klan had a rally about a year after I entered my injunction. And they were carrying signs about me and about the end judge who gave no justice. The Vietnamese felt that they had received justice, and in fact, they are now the predominant shrimp fishermen in the area. The Klan organized a flotilla as part of this intimidation, where a shrimp boat went down the channel. Klansmen were on the boat in their robes, armed, and with of all things, cannon on board. So it was intimidating, and it got national, even international attention. I like to believe that it helped to quiet, so to speak, the relations between the Vietnamese fishermen and the American fishermen. There were a lot of people of goodwill in the area. That's the area where NASA is located. So there were a lot of professionals in the area who did not welcome having a reputation for this kind of activity. So the community mended its ways, and things went well, except for that one incident, which I was not aware of, actually, and it was not brought to my attention by the plaintiff's lawyer. They were represented by the Southern Poverty Law Center in Alabama and local counsel. So it was just one of the many high-profile cases that I seemed to have almost as soon as I became a judge. Cases involving acupuncture, cases involving an ordinance that limited the place where topless bars could be located. Perhaps it was by chance, but I got busy real quick and well-known real quick.
Wow, what a profound experience to have on the bench, and I am just so moved by your courage. I mean, you are in your courtroom, standing up, talking to a person who is leading an organization that is very much against you and everything you stand for and are, and yet you held your ground and you remained in the case, and you also remained a vision and a model of justice of what a court is supposed to bring, especially as you mentioned the People's Court, which you very much told your staff and everyone that this is the People's Court. The people should come in, and And that organization is part of the people. And so the fact that you were able to dispense justice in such difficult circumstances is a testament to your integrity, as well as your high caliber as a jurist. So that is fantastic.
Well,
So
thank
yeah,
you,
please.
but we were well protected. I was well protected. We did not have metal detectors at the entrance to the building, to the federal building, but they installed some metal detectors at the entrance to my courtroom. And I told my two law clerks, I told one of them, keep his eye on the left side, and I told the other, I said, you keep your eyes on the right side, and I will keep my eyes on the entire courtroom. So it's called doing your job. As far as I feel, it wasn't a case that I welcomed, but it came before me.
So while I'd love to talk more about those fascinating other cases that you mentioned, and there's many more out there that our audience can find information about on the internet, we'll have to move forward in time a little bit. So after you left the federal bench, you served as an arbitrator with JAMS for a little while. And you also taught at St. Mary's University School of Law in San Antonio. In 1993, you were about to start a full-time teaching career. You had accepted a post as a distinguishing visiting professor at Texas Southern University, Thurgood Marshall School of Law in Houston. But then you received a call, and the call was from the United States government asking you to become a judge on a brand new international tribunal that would come to be known as the International Criminal Tribunal for the former Yugoslavia, or ICTY. You are one of the rare attorneys and jurists that has actually had the opportunity to design a procedure and evidentiary system from scratch at the ICTY. When you became president of the ICTY, you were charged with building both a physical institution and a procedure from the ground up. And your contributions were so appreciated that when you were leaving the ICTY, a book, Essays on ICTY Procedure and Evidence, was commissioned in your honor. So what was it like, Judge McDonald, to build an international institution from the ground up, both procedurally and physically?
It was wonderful. Who wouldn't like to design a court in their image? There were 11 judges, all from different legal systems, about evenly divided between civil law and common law. We met under the leadership of Antonio Casese, who we elected president. He was a difficult taskmaster. We met, though, really almost around the clock, although we only had one secretary. So we met in the Peace Palace. We didn't have a facility. We had ourselves, really, and then the drafting of the rules. The states, member states of the United Nations, were permitted to submit proposals for the rules. The United States submitted a major one, which I had some input on, and it turned out that it became the basis, at least in terms of the form, that the way that the rules were organized. We finally were given a premises. The UN located a insurance building, would you believe, the Aegon building. I visited it, the building, with the president and Judge-Arbitrator to see if it might be acceptable. It was difficult, really, to make a judgment because it looked nothing like a court, like a tribunal. There was no courtroom. So we met there and continued to draft the rules. We had difficult times sometimes. One kind of dispute in particular involved trials in absentia, and I opposed it. Now, keep in mind that it's not uncommon to have those types of trials in the civil law system, or at least a combination. Whereas in the United States, Crosby versus the United States is a standard, so that if someone appears and then absconds, the court may proceed. So Judge Casese and I, because he was the proponent, went round and round and round, probably for 3 days, and eventually we reached a compromise. Judge Casese passed after he had left the tribunal, and after at his memorial, there was a photograph of he and I shaking hands, and you would have to have known Nino, as we called him. He was very short, and he had this twinkle, and we used to banter all the time. But we finally reached a compromise. We did not have trials in absentia, but we did address some of his concerns by having kind of a publication of the case, so that the world community would know what was in the indictment. When I became president, in the beginning, we had difficulty, obviously, with the transfer of persons who were charged by the tribunal. Since it was a Chapter 7 mechanism established by the Security Council, states were to comply with our request, but they didn't. Eventually, it got to the point where S4 would arrest for us. And in 1997, I think it was 11 persons turned themselves over, actually at the urging of the United States. Robert Gelbard, I remember, and I met him actually subsequently. You could see him at the airport, really, escorting the 11 accused. So by the time I became president in 1977, in 1997, excuse me, we had a goodly number of accused, but we didn't have the space. By then, we had built our courtroom. We had conducted one case, the Tadage case, which I presided over, and with me was a judge from Malaysia, Judge Bora, Lal Bora, and Ninian Stephen from Australia. And he had been the Governor General of Australia. In any case, we only had one courtroom. So part of the job of the president was to beg, and we were able to get funding from states, not the UN, but from states, to build 2 additional courtrooms. Then we needed to staff the 3 courtrooms. At that time, we only had 2 trial chambers. So I went before the UN Security Council and begged again, and they amended the statute to add a 3rd trial chamber and additional judges for the appeals chamber. Then my health changed. It's very difficult to maneuver inside the UN. I mean, it's like a football field, really, at least as far as I was concerned, because I had difficulty with my mobility. And I have traveled to Egypt, I remember, and China and other places as part of my job as president. But I finally resigned, and then I went to the Iran U.S. Claims Tribunal, where I could just sit down and bark, as they say about some judges. It was sad, though, because my fellow judges took me to dinner, and each went around the table telling me why I should remain. It made me cry, really. And judges aren't supposed to cry, I presume, but I did.
Wow, that must have been moving to see how much your colleagues adored you and wanted you to stay. But I can understand, it was time for you to to move on to your next challenge. And so after you left the ICTY, you actually were thinking for a little while of returning to JAMS as an arbitrator. But then in 2001, as you mentioned, the United States asked you once again to serve as its representative on an international tribunal. Here, it was the Iran U.S. Claims Tribunal. And on that tribunal, you were the first woman and the first Black woman judge on that tribunal. And so, you already mentioned a little bit of what you were doing at the ICTY to build the institution. Tell us a little bit about how you built the institution at the Iran U.S. Claims Tribunal. And also, in terms of building the institution, you also built relationships. So tell us a little bit about how you were able to bridge that cultural divide with the Iranian judges in particular on the court.
Well, before I joined the tribunal, I had visited the tribunal when I was at the ICTY, and I was told by one of the American arbitrators who was showing me around, he said, don't put your hand out, because if you do, the Iranians will not shake it. I knew that, I think, but we didn't see any. So yes, Iranians have a culture that puts women in a different place than we do in the United States. For the most part, we still suffer gender bias with respect to, whether we should be in the marketplace or whether we should be home taking care of babies and cooking. In any case, they would not shake my hand. None of them. Actually, one of them I had known when I was at ICTY, and he did come to welcome me, came to my office and welcomed me. Then he made a very derogatory comment about my law clerk, who was Jewish, but he welcomed me. Some of them used to call me Lady Judge during deliberations, which I enjoyed. The hearings were different than what I had been exposed to, where there was give and take. And then in international arbitration, they kind of give speeches. But I had been selected, so the official with the State Department said, because of my multicultural experience and my experience leading the tribunal that was very multicultural. So they called me Lady Judge, but I was so vocal, and maybe I'd like to think convincing. I didn't convince them, but I thought convincing, that they began to respect me. You can tell it. I've been around, you can tell it. Finally, one Iranian judge came to my office. We were talking about possibility of settlement. And I used this opportunity to just get off my chest my feelings. And I explained to him, I said, I respect your culture. I always wear a jacket. I never show my bare arms. But look, when we are doing our job here, I'm not a lady judge, And so we talked, and he told me about his family and the role his mother had played. And before I could get up to escort him to the door when we finished, he came around the desk and shook my hand. And he didn't shake it in public. I understand that, but he shook my hand. So we didn't become friends, but you don't have to be friends. It's a question of respect. And later, actually, I did have some issues, not so much with the Iranians, one with a third country arbitrator. I didn't tell you about this, Victoria. He passed what was, I gather, a chapter of a book that had then been copied, and it was entitled The Black Dog. He passed that to me during a hearing. All of us were sitting on the bench. It had to go through my two American colleagues. Now, the reason it was, well, the reason is that he was racist, but we had had a dispute over the temperature in the hearing rooms. He would wear a raincoat, would you believe, over his jacket, suit jacket, over his red vest, sweater vest, I remember. And I have a condition that I have to keep the temperature low, and so I disputed it. And I guess you're not supposed to speak out. And that was his response. You know, when I saw him, what do you do? I just said, you know, like, what? Another country arbitrator, though, congratulated me, so to speak, on my high morality, but he did so in the context of a very dispiriting incident that I had with one of my American colleagues. He had been giving me a lot of trouble really throughout, you know, just petty stuff. They had never worked with a Black woman. You have to understand that, you know, it's a culture shock. But finally, he disrespected me really in such a way. It was egregious. So egregious that the full tribunal took up the issue. And he still adhered to his position that he was not responsible, that he had not been involved. It was quite a meeting because the full tribunal knew the facts and knew what happened. But you might call it a sense of privilege, something that he adhered to his denial. So shortly thereafter, it was right before I left, actually, I was having eye surgery and really had to retire. The third country arbitrator congratulated me on my high morality. He was subtle, gave me a book written by Jimmy Carter, his only book of fiction, and inscribed it, you know, you're highly intelligent and you're also highly moral, something like that. That was his way of saying this is not right. And that bothered me because I welcomed his praise, so to speak, but I was kind of saddened that other countries saw what I saw. Same thing happened with Iranians, actually. The Iranians at one point suggested that I move across the table, that I might be more comfortable there because of interventions that were made. But I learned a lot. Tom Johnson in particular joined the tribunal. He's a good man and an excellent arbitrator. The last case that I had, I learned a lot from him. So it was a mixed bag, you know. The Iranians you have third country arbitrators, you have your American arbitrators who come from the United States and the history that we have. But I'm a tough lady and an old lady. I'm glad that an arbitrator such as yourself, a young arbitrator, didn't have to go through this, but you're tough too.
Well, thank you, Judge McDonald. And
Did that fully answer your question? Some of these we haven't even discussed some of this, so I don't mean to shock you. I don't mean to even dissuade you from pursuing the practice of international arbitration. Your nickname, I told you, was excellent. That's what people call you. Really, or one person. I didn't know.
Well, thank you, Judge McDonald. You were very, very kind. And, you know, I stand on your shoulders and the shoulders of others like you who have paved the way for people like me and people who look like you and I. And I think that being in those places and being in those difficult situations, not only were you able to have an impact, but I think you also changed hearts and minds of people who, as you mentioned, had never worked with a Black woman before, and grew to respect you, grew to appreciate your counsel, and then asked you, hope that you wouldn't leave. For example, when we talk about the ICTY, and I'm sure that some of your colleagues on the Iran-U.S. Claims Tribunal also had wished you had stayed a little bit longer, but nevertheless, you moved on, and in 2014, you were nominated as the first Black honorary president of ASIL, the American Society of International Law, and only the second female honorary president of ASIL in its entire history. And one of your outstanding achievements as honorary president was creating BASIL, Blacks of the American Society of International Law. And this was a continuation of the project on African Americans in international law that you had started in ICTY with your third law clerk, Professor Bartram Brown, in the 1990s. So tell us a little bit about how BASIL was created and its mission, and also how it has connected with international arbitration, for example, through Young ICA hosting workshops and other events to try to increase the number of Black arbitrators. So tell us a bit about how BASIL got started, and also how BASIL is working with the international arbitration community to increase the numbers of Black arbitrators and also Black counsel.
Betsy Anderson, who was then the executive director of BASIL, called me. I had known her for some time. She, I believe, was a clerk for one of the judges with the ICTY. And she asked me if I was interested in becoming the honorary president. And I told her, I have finally retired. And then she explained the duties, it's honorary. And so I said, yes, I would be honored to be the honorary president. I had in mind, though, if not when she spoke with me, certainly shortly thereafter, that this would give me the opportunity to continue an effort that I made with my law clerk, Bartram Brown, to increase the number of Black persons in international law. I didn't see people who looked like me. I remember a dean of a very prestigious law school visited me when I was at the ICTY. And when I walked into the door, we stood there kind of chatting. He said, I'm so happy to see you here. He said, most of the people in international law look like me. He was a tall, distinguished looking gentleman with gray hair and white. So it was only, if nothing else, if things happen and you want to have someone to talk about things that are peculiar to our experience. And I'd asked Art if he would help me since he had been a professor. And we created what was called the Project of African Americans in International Law. And the goal was to once again increase the number of African Americans in international law. So I had just left the Willig luncheon before I attended the business meeting where my election or selection would be announced. And I was just dazzled by the progress that Willig had made since I had attended the meetings, or at least one meeting. I think it was at the Fairmont Hotel. And we met in the restaurant. Maybe I'm exaggerating, but it just seemed like I could count the number of persons on two hands. In any case, I was dazzled because it was just overflowing. And as you know now, it's one of the best well-attended luncheons, but they have such a strong force of women doing good work to increase the number of women and provide them with guidance and support. So that encouraged me. When I walked in the business meeting, I said, I want something like this. So I told the group just what I told you. I was lonely, and no one looks like me involved. And to my surprise, they decided Lori Damrosch was the president then to create a core project of ASIL. And we then met several times and came up with the names. And it was also, this request was supported strongly by Donald Donovan, who was the outgoing president. And I had known him from my time at the ICTY. He appeared before me with, I think, 10 other amicus curiae in a case. And that was something, because I was sitting there as a single judge dealing with 11 amicus curiae, many of them professors. And you know how professors are. They want to talk and show you. So I knew him, and Betsy was executive director, and she made sure that it got done. And I mean, she made sure. She was the force. That, in terms of, and you were asking about international arbitration, which I haven't been involved in, only at the Iran U.S. Claims Tribunal, showed me how change could occur. It showed me that once the leadership, so to speak, in this instance of ASIL, made a decision to open up the field, essentially. I don't mean that, that pejoratively, but to focus on increasing the numbers of Black Americans. It was done, and seemingly with ease. We have had, I was a co-chair originally. Adrian Wing was the other co-chair. And I left the position after 3 years, hoping and knowing that my successor, Matu Macau, would do a good job, but also because Adrian had told me that the practice at ASIL was that every year we would open up the co-chairs. And so I would announce at the end of the first year, is anyone interested? No takers. End of the second year, no takers. Finally, at third year, I said, I'm 75 now. It's time for me to go, pass this on. So we had a mentoring fair session at Howard University. We developed I think, at least in the beginning, a strong relationship with the Black Law Students Association, with their chapters at area schools, which is important if you want to reach the group that is the focus of BASIL. When the Council on Foreign Relations sent me a flyer regarding a international relations conference or something that they were doing for minorities, young minorities. And some of our members, I just passed it around through the membership, and some of our members who are professors just jumped at it and suggested many persons to participate. And we, BASIL, gave scholarships to fund their attendance. Before that, we had hoped that Black law students would be admitted free of charge at the annual meeting. That didn't work. It didn't work, even though I wrote, as what I call the Baki brief to the administration, explaining what needs to be done, that it's not discrimination against other persons. It's a matter of responding to a history of exclusion, whether it was intentional or not, that some, I hate to use the word preferential, but some focus needs to be given. Well, it didn't work then, but we gave scholarships. We have a good bank account. People are giving to BASIL. and hope that you continue to give to Basil, everyone. So I just wrote the membership, any problem with this? They said no. We had about 17, 18, maybe 20 members, white, black, African, the gamut almost, Latino, Carlos Vasquez, and others. So basically what we were doing was reaching out to law students and young professionals to show them, to basically say, come on, the water is fine. Come on into international law. Because if you look around, it's historically been Caucasian. We did the same for international arbitration. Donald Donovan, who was a member, was president of ICA, and he suggested to young ICA that that they contact us and do a workshop. We did too. We're fortunate to have 3 very capable Black women arbitrators. Melita and Natalie and Taffy. They took charge and basically worked with young ICA for these workshops. And I like to believe that they were successful to introduce to law students and young professionals the field of international arbitration. By definition, international law, and most particularly international arbitration, where the arbitrators show their faces to the world, needs to reflect our country. But it's difficult because law students want to know that employment will follow their choice of the field. And the perception was that international arbitration was homogenous, but all white. So that's about where we are. I think more effort needs to be made in terms of the international arbitration field. And there's kind of a way to go about it, at least based on my experience with Basil. And the first is to determine really whether or not there's a problem, whether there's an underrepresentation of Black Americans in U.S. international arbitration. It seems that there is. It seems that it is based on writings by persons, Black Americans who have had the luxury or the luck of being involved in international arbitration. It's also, to me, shown that there's underrepresentation based on statistics. And finally, that in fact, there is availability of Black Americans to work in this field. Ben Davis, who was involved in international commercial arbitration and the administration of it for 35 years or so, has written extensively on this topic. And he feels and has concluded that there is a color line in international arbitration. He's written several law reviews, one in 2003 and one in 2014, I think it is the most recent one, where he basically canvassed, not in a scientific way, but by reaching out to arbitrators who were in the field to ask them how many had they seen. Had they seen any Black Americans? He concluded that there's a dearth, that those that are in it are on a, what does he call it? Separate lagged track. Secondly, with respect to statistics, Catherine Simpson recently, I think in June of last year, published some statistics. And the statistics were based on a her review of websites of the top 500 top legal, top law firms. She reviewed the websites, again, with the goal of finding out the involvement of Black Americans. And she found that let me see, I have the exact figure here, that as of 3,430 international arbitration practices within these law firms, only 57 were Black Americans. There's something wrong there. I mean, I accept her analysis. It's been public since June, clearly. And finally, there is availability. Nancy DeVedin and Catherine Simpson prepared what they refer to as the new list of persons of African descent with a U.S. nexus who have various levels of training and experience in international arbitration. There are persons, names on there who are ready now, and you don't see them involved within international arbitration. So clearly there's a problem. There's a question in my mind, well, maybe not a question, but a question about the way that the whole issue is addressed, because are Black Americans valued in international arbitration? And the reason I raise this is that I've seen some statements that say there are plenty of women, persons of all races and nationalities in international arbitration. So what's the problem? It's fully integrated. Well, the problem is that when you talk about these minorities, you're talking about persons who are of the majority in their country of origin. That doesn't cut it. We're talking about the face that international arbitration gives to the world. And the fact that you may have many or some Africans, they're the majority in their country, please. So, you know, the question, the second step, so to speak, is do you value the presence of Black Americans? And finally, as I was looking at it, question being, what do you do about it? I recall the example of Basel. And I also recall, and Ben Davis has written a lot about this also, the growth of women in international arbitration since the 80s or 90s. And now you have a pledge, equal representation in the arbitration pledge for women. And when I say women, unfortunately, I mean white women, because recently, notwithstanding, and I'm sure people would say to me, what? You have 3 Black women arbitrators in Basel. What do you mean there aren't Black women? Well, you know, look at the report of the recent report again, the last year, or maybe the beginning of this year. No, I guess it was last year. By the American Bar Association Commission on Women in the Profession, where they found that Black women are sorely treated differently. If you read the report, it's almost heartbreaking. 100 plus, 100 and some Black women were interviewed, and their experiences show you what's going on. And it shows you too, that although women as a group are doing better, better, but still not where it should be. Race trumps gender because Black women are the lowest in all categories, of all categories. It would be Black women, then Black men, then women, and then white men. So this needs to be changed. It needs to be changed, particularly.
And how do we do that? How do we do that, Judge McDonald? What do you think the International Arbitration community, should do?
I'm not here really to tell persons what to do or how to go about it. I'm here really to offer examples of what has been successful. And I would say Basil. The first thing is that they should look at this new list of over 100 persons of African descent with the nexus to the United States and see just where they are. The second thing I think, though, is this so-called pipeline. You know, most of arbitrators and people say, well, we don't appoint, the parties select. Well, and that's a different issue than the pipeline, but the two arbitrators that are selected by the parties certainly can decide on the third, and they need to focus on diversity. When I say diversity, I mean diversity and inclusion, meaning, you know, the pudding is in the eating, and so include Black Americans, minorities. If they take that step, that would help. Ben Davis again has at some workshop posed that question and asked for comments. It's very interesting. You need to read it. But the other thing is the pipeline that I first began to speak about. We see where Black women are in the rankings and Black men. So the chances of them getting in the pipeline, because it would have to be, not have to be, but primarily be in a law firm, is difficult because you go back to, well, let's look at law firms. What is the representation? If they're not there, they can't get in the pipeline or the track for international arbitration. They need to expand it. There are many professors who are able and have arbitrated cases. And I have taught, you know, sometimes professors are the ones that have, not that they're not busy, don't take it personally, but they do have time to do this. And they approach it a little bit differently, I think. Professors offer a different slant, so to speak, I think. So again, just do it. That is one of my mottos in life. Just do it. I tell my adult children, just do it. And I know it's Nike's brand, but I can use it. So I say, just do it.
Well, thank you.
They know how to do it. I'm sorry, I'm getting, you know, it's with the Black Lives Movement this year, we had the high numbers, 26 million people protesting throughout the United States because of racial violence by the police. But more than that, they were looking and challenging racism. And it was welcomed by the international community. They supported it too. But then what came after it? The January 6th storming of the Capitol, or insurrection. I think insurrection is a better word for it. So we moved forward in terms of race relations. And now we've gone back with thugs, if I may say, storming violently the Capitol, carrying the Confederate flag. You know, more incidents. The deaths of 5 people who were, as a consequence, at least, of the insurrection. So, as I said, international, American, international, US international arbitrators present an image to the world. And the question is, what image are you going to present? Are you going to present what maybe, anywhere, the low is 15 million, the high is 26 million, over 95 or 75% it was white. Whites feel about the state of race relations. Are you going to present that image? Or are you going to present the other image? Now, I'm not saying there are very few people, relatively speaking, who would participate in something like that, but there are more who condone it. And foreign countries can draw assumptions about your preferences based upon your actions. So it seems to me what we got to do, what the field should do, is do it. It can be done. It was done for women, as it should be done for women. Do it.
Well, thank you.
It saddens me, really, and it pains me, really, in a sense, to talk about this. And you can see how I've become a little emotional or passionate about this, because it's something that I've been involved in more than 55 years. That's why I went to law school. And it saddens me that it saddens me that not a lot has changed. It was not until I was 23 years old that the Civil Rights Act of 1964 became effective. Until that time, I was denied, because of my race, the full rights of citizenship. And so it's not been it hasn't been it doesn't go back to 1863, this kind of attitude. It goes back to 1965. And I want to see some change.
Mhm.
I'm in the twilight of my life, and I want to,
Oh, don't say that.
along with my grandson, I want it to be a better world for him. That may sound
Absolutely.
like Pollyanna, but I don't mean that. That's what happens when you have a few years under your belt.
Absolutely. Well, thank you, Judge McDonald, for that rousing call to action. Just do it. And so we'll certainly take that to heart as we move forward and try to progress the international arbitration community. So sadly, this is all the time we have for this interview. I'd like to thank David Wynn and the ITA staff, Monica Shom, Cecilia Flores-Weda, and Krishan Johnson for helping to make this event happen. I also enthusiastically encourage you to attend the event on Thursday, March 25th, at which Willig will present Judge McDonald with the 2021 Prominent Woman in International Law Award. And that event will explore some other very important parts of Judge McDonald's life that we didn't have the opportunity to discuss here today. But registration is found on the ASA website for that event. So first of all, thank you. Thank you so much, Judge McDonald. You have shared your wisdom. You have shared your experiences. You have poured your heart out to this community. And we are so grateful for you and for your remarks. And thank you for allowing me and ITA to share your life and legacy with the international arbitration community and the world. So everyone, please join me in giving Judge Gabrielle Kirk McDonald a virtual round of applause. Thank you so much, Judge McDonald. Really, we really appreciate it.
Thank you. You're quite welcome. Did you see